like to speak, okay? Bill? Please state your name and spell it for the.
My name is Phillip Scheel, Phillip Scheel. My comments mostly echo that of Mayor Ryan, Mayor Estenson, Commissioner Ryan, and Mrs. Williams, talking about the process. So Bob and Paul, last month in voting to hold this public hearing, you have violated the land use plan. The TP retreat land use change issue is being deliberated at the Wyoming Supreme Court. Michael has not submitted a land use change request. You have no application to approve or deny, so you can't make any decision to approve the former application today. That application has already been evaluated. So in order to hear this case again, they must reapply, as I'm sure that you have already been advised by the county attorney and the county planner and the Land Use Planning Commission. They have not been prohibited from applying again. If they do, then they can take their application back through the entire land use change process. You can't allow anyone, not even your friends, to bypass procedure. After the denial of the only land use change brought by the TP retreat, Michael and Michele sued. That ended when the judge upheld the previous commission's decision to decline the change, ordered that the Stevens pay the county $40,000 in penalties, and place an injunction on further operation of unpermitted illegal business. One of the roles of county commissioners is to manage the county's money. Let's examine your fiduciary responsibilities. While it's true that the county has spent over $160,000 defending ourselves, you need to understand that this money was spent defending our county policy. If you now choose to let them have their way after the judge has ruled that they did not follow the rules or meet the criteria, you are opening yourselves up to all kinds of litigation. If you also choose to forgive the $40,000 penalty, which doesn't even come close to covering the cost of our defense, it will be a failure of your responsibility to the county's taxpayers. So let's talk about solutions. Don't be foolish holding this kangaroo court. Hot Springs County land use is a policy, one of the only ways the county commissioners can actually sort of legislate, given that authority by the state legislature. If you think the plan doesn't work well, amend it, or hell, repeal it altogether. Don't be arbitrary. Listen to the legal advice of the county attorney. I'm not an attorney, neither are any of you. You are rookie commissioners. Do not use your newfound power to help your friends or pick winners and losers by deciding whose property rights are important. These neighbors actually own the land. Have you no respect for your offices or your sworn county duties? Thanks, Sean.
Thank you, Bill.
Thank you.
This is, as a further clarification for moving further, I spoke to an attorney once before too, and his exact about the particular easement and about the property owner's land, just for clarification, his said the right of the easement holder is superior to the landowner's rights. His exact words. He said their rights are superior to the landowner, cannot put obstructions, et cetera, on that particular easement. I just wanted to clarify that about rights, because according to the attorney that I spoke with, he said, once you have an easement, your rights are superior, the exact legal terminology, superior to the landowner's rights. Okay, next.